Well, turning now to Oregon's public defense crisis. Last fall, two public defense firms sued the state, arguing a new contract would force attorneys to take too many cases, violating their ethical limits. Well, the public defenders recently won that case. A Clackamas County judge sided with the attorneys and against the Oregon Public Defense Commission, or OPDC. The judge got rid of part of the contract, which allowed the state to penalize public defenders for refusing to accept cases beyond what they believe they can ethically handle.
What that actually practically means is that when you receive legal representation from our office, you know that you're receiving representation from an attorney that isn't just going to treat you like any other person. They're going to have the time, the ability to sit down, listen, investigate, research, prepare your case adequately. You're going to have an attorney with the ability to say no to additional cases that would pull their attention away from working on your behalf.
In a statement, the OPDC told us they are analyzing the ruling and remains committed to protecting Oregonians' constitutional rights by ensuring that eligible defendants have access to effective legal representation. Now, it's important to note that right now, the ruling only applies to two public defense groups, one in Marion County, the other on the southern Oregon coast. But plaintiffs believe this should be the baseline for the entire state. They want to argue the case before the Oregon Supreme Court.
We're lacking guidance at this point. And we have, while we were successful and won at the trial court level, there are some bigger questions that need to be addressed by the highest court. One of those questions is, can Oregon be allowed to provide something less than effective assistance of counsel? It is a funding issue. I think that the Roberts decision is pretty clear that the role of counsel is critical.
Now, the Roberts decision came from the Oregon Supreme Court last month. According to the ruling, criminal defendants must be given an attorney within 60 days for misdemeanors and 90 for felonies, or the case must be dropped. About 1,500 cases were immediately impacted. Now, we recently told you about a Hillsborough children's clinic where a former employee was accused of embezzling more than $200,000. There were two criminal cases against that employee. One has since been dismissed under the Roberts ruling. In the other case, a state defense attorney took it up at the last minute. But the backdrop to all of this is Oregon's ongoing public defense crisis. We've talked about it a lot on this show. People are being charged with crimes, but there aren't enough defense attorneys available to take the cases. The state says the problem is starting to improve. Let's look at the numbers. By the end of January, there were about 2,500 unrepresented cases in Oregon. That's down from nearly 4,000 the same time last year. The state wants public defenders taking more cases to eliminate the list of unrepresented defendants for good. Now, next steps in regards to the lawsuit over caseloads, either side can petition the state Supreme Court to take a look, and that's what the public defenders want to do. Right now, they're waiting on a full written version of the Clackamas County judge's ruling, and that's expected to come by the end of this week.